If you've been discussing COVID-19 science, you're not going to get a hearing. If you're arguing that the college should never have proceeded against you because it never had reasonable and probable grounds for its investigation, the Court of Appeal is not going to hear you. So we have a crisis of legitimacy in our court system now.
Today's report is somber for free speech in medicine after 3 Ontario court justices at the appeal court upheld an October 2023 tribunal decision that found Dr. Mark Trozzi ungovernable, branding him a spreader of misinformation guilty of professional misconduct and incompetence. The College of Physicians and Surgeons of Ontario, CPSO, has been investigating the formally licensed and practicing emergency room physician for his claims against what he refers to as the criminal COVID enterprise. Justice Myers, Newton, and Shore determined that Trozzi is free to express himself as he wishes, but he is not free of the consequences of that expression, which included complete revocation of his license to practice medicine and nearly $100,000 in fines payable to the CPSO. Trozzi's lawyer, Michael Alexander, joins me to share the details of this ultimately unsuccessful appeal and his legal arguments, including that Trozzi has remained unrefuted on the COVID science, even though the CPSO clung to their assertion that there is an overwhelming consensus from well-known, reputable, and authoritative sources that the COVID-19 vaccines are safe and effective.
The main issue that I put before the court was that the tribunal excluded from consideration, didn't even mention material evidence. Material evidence is evidence that could affect a finding of fact that goes to the ultimate decision of the body in question. I had a cross-examination of Dr. Garden, the college's main expert witness on science, and that cross-examination didn't go very well for him. In fact, I established that there were dramatic contradictions between his expert report and his actual oral testimony. That's called impeaching the witness. Also, in the course of the cross-examination, I got him to agree with basic points of COVID science that Dr. Trozzi had brought forward and that the college had characterized as misinformation. So by the end of the cross-examination of Dr. Garden, I had turned him into a witness for Dr. Trozzi. Also, he admitted on cross-examination that while he was of the view that the shots were safe and effective, absolutely, in his oral testimony and in his report, he had no scientific citations to support that point of view. And further, he admitted on cross that he had never read Health Canada's authorization documents for the Moderna and Pfizer shots. So my point with the tribunal and with the court on October 8th was, how can Dr. Garden act as an expert witness going to the issue of whether the shots are safe and effective when he hasn't even read the underlying documents? I mean, it is outrageous that the tribunal would not even mention that cross-examination when it weighed the evidence. That is clearly evidence of bias. And once you have bias in a decision, the whole decision has to go.
Part of the justice's decision states that freedom of expression is not a magic mantra that frees us from responsibility and accountability for our lawful obligations, and that freedom of expression gives people the ability to choose to express themselves, knowing that they may be held accountable for doing so. But Alexander notes that this fundamental right is inherently unrestricted, contrary to the court's decision.
I have argued in a number of different cases. I have conducted a fundamental review of our Supreme Court jurisprudence on free speech and free expression. In 1938, in the Alberta reference case, the Supreme Court said that there's an absolute right to express a minority or dissenting opinion on any subject, and that is a right guaranteed to you by parliamentary government. It's an innate right in the very form of government that we have. And it's quite clear that the Supreme Court picked up this way of looking at free expression in a number of cases in the post-charter era. So I think it's very clear that Canadians enjoy an unrestricted right to express a minority or dissenting opinion. And when the court there is talking about consequences, they are merging this issue of expressing a minority opinion, in this case about COVID-19 science, with the issue of how a professional, the form in which a professional expresses his substantive views. Okay? There is clearly a constitutional right to express any minority view in terms of the substance of what is being expressed. You might make an argument that professionals are under a certain obligation to express their substantive views in a particular form that is rational and reasonable and considered. And I think the court here confuses the two issues, the right to express a minority point of view with the way in which one expresses it. And that is very muddied in the course of the decision. And I find that aspect of the decision very problematic. Even in the Peterson case, the court said, we don't pass judgment on the substance of Peterson's views, only on the form in which he expressed them. Now, here we have that the court has gone one step farther in Trozzi, and they've said, well, expressing the substance of your views may be subject to limitation and limit. And I think that is clearly a statement that is inconsistent with 80 years of Supreme Court jurisprudence.
There were several points of contention with Trozzi's written statements, including in the decision where he called for the lawful killing of Gates, Fauci, and others, which Alexander notes should have been balanced against his scientific arguments.
Well, you have to balance those extreme or inflammatory statements, which are essentially political statements, against the thousands and thousands of pages of rigorous science that Dr. Trozzi has published on drtrozzi.org over the last 3 years. So you have to kind of balance that. My position is if the college wanted to take him down for making extreme statements that they regarded as unprofessional, there would be a ground for that. And when we went to the court, on appeal, if the court wanted to say at the end of the day, though we vindicate Dr. Trozzi on a number of different issues, on the issue relating to the form of his expression, he has gone too far and the college was justified in revoking his license. So I could have lived with a loss on that basis. But what I was hoping for was a resolution and a ruling of these other egregious violations of basic legal principles that occurred during the tribunal hearing. So if we got a ruling on some of those points, that would have helped a lot of doctors in the future. But in order to go after, essentially to deal with Mark's inflammatory statements, in my opinion, the court ran somewhat roughshod over those other issues in order to get to the result that they wanted. And I would have preferred a different decision. And if there were an appeal, we would have to deal with those issues.
The tribunal did note throughout that a finding of professional misconduct would affect Trozzi's fundamental right to freedom of expression, but Alexander says this reference is just lip service.
And then they downgraded his expression and said it was low-value expression that didn't deserve protection. So they adopted a framework between high-value expression and low-value. Now, insofar as Dr. Trozzi made political statements, all political statements under our constitutional law are comprised or can be defined as high-value expression. In fact, political expression deserves the highest protection under the guarantee of free expression. So the college kind of plays with this high-low distinction and then categorizes Dr. Trozzi's political expression as low value. And in the process, they also characterize his views on COVID-19 science as low expression because they characterize those views as misinformation. And this goes to the whole issue of what is wrong here. I mean, if you were to summarize what the tribunal found, the tribunal found that Dr. Trozzi had been spreading misinformation about public health matters concerning COVID-19, and that he had caused patient harm. He had endangered the public. But in the course of the tribunal hearing, because of my cross-examinations and the submission of Dr. Trozzi's own reply reports in which he covered COVID-19 science, Dr. Trozzi, at the end of the hearing, was unrefuted on his views on COVID-19 science. So you cannot make the claim that he was spreading misinformation. And yet the court in Trozzi has just picked up that theme and said at the end of the day, yes, Trozzi was spreading misinformation. This was a threat to the public, and therefore we enforce this way of looking at things and affirm the tribunal decision. That is profoundly problematic. What does this mean? It means that a college tribunal can manipulate evidence sworn under oath. They can manipulate it to create a situation where a member is perceived to be spreading misinformation, and then they will proceed to censor that individual by revoking his or her license. I might say on this point that when you consider charter rights, so in this case, the right to free expression, there are reasonable limits that can be placed on free expression under certain circumstances. So Section 1 of the Charter allows that to the government. So in that case, the tribunal, when it was assessing the free expression argument, had to weigh the college's statutory objective, against Dr. Trozzi's right to free expression and decide which deserved priority given the evidence in the record. I'll tell you what's problematic about that. The statutory objective that the tribunal used was the need to prevent the spread of misinformation during a public health emergency. You cannot find that statutory objective in the Regulated Health Professions Act, the Health Professions Procedural Code, the Ontario Emergencies Act, the Ontario Reopening Act, or its regulations. The Ontario government doesn't have the right to censor you during a public health emergency. It doesn't have that statutory objective in its legislation. How does the college find that statutory objective? And yet, the court says at the end of this decision that this is a worthy statutory objective to justify crushing Dr. Trozzi's right to free expression. That is an absolutely astounding conclusion.
Overall, Alexander says further litigation is unlikely to garner successful results in favor of Trozzi, given previous precedents.
You only get a second kick at the can on appeal by requesting leave to appeal from the Ontario Court of Appeal. It is within the discretion of the Court of Appeal to accept or reject an appeal of a lower decision. I am not optimistic that the Court of Appeal would accept the Trozzi case. They turned down Dr. Luchku's case, which I also argued. They turned down Dr. Peterson's case on the same day. They have already sent the message that we don't want these COVID-19 loudmouth professionals messing up our administrative state. So if you're somebody who speaks too politically, like Jordan Peterson, the Court of Appeal is not going to hear about whether somebody has trampled on your right to free expression. If you've been discussing COVID-19 science, you're not going to get a hearing. If you're arguing that the college should never have proceeded against you because it never had reasonable and probable grounds for its investigation, the Court of Appeal is not going to hear you. So we have a crisis of legitimacy in our court system now.
To find the other side of the safe and effective story, please visit nomoreshots.ca and check out my previous reports there. You can also support our work and sign a petition and form email to Federal Minister of Health Mark Holland, calling on him to revoke market authorization for these injections. That's nomoreshots.ca.